Hi, I'm Jennifer Burkhan, one of the paralegals at McGinnis Elder Care Law. This is video 3 in our 5-part series on the revocable trust. We'll be talking about how assets are transferred or titled to the trustee of the trust. When we're working with clients, we offer detailed instructions for every possible type of asset. In this video, we'll look at a few of the most common assets that end up in a revocable trust. Let's look at a person's residence. In most cases, the grantor will title the home in the name of the trustee. This will not trigger a reassessment by the tax assessor because it is not a change of ownership for property tax purposes. There will be no transfer tax. The transfer does not need to be reported to the homeowner's insurance company or the mortgage company. If the grantor lives in a cooperative or a condominium, your best bet is to ask the manager of the cooperative or condominium how it should be transferred to the trustee. For savings accounts and certificates of deposits, most banks should be familiar with transferring accounts into the name of a trustee of the revocable trust. Some may require a copy of the trust agreement or an abstract of trust. The grantor should keep a copy of any new card or document signed to effect the change. Checking accounts are often a different matter. While such accounts can be titled to the trustee, some people prefer that their household checking accounts remain outside the trust, mostly so the world is not put on notice at the grocery store of the existence of the trust. It's always a good idea to avoid carrying large balances in the checking account and to name the trustee of the trust as the pay-on-death (POD) beneficiary of the account. For life insurance policies, the life insurance company or agent should be asked to furnish a change of beneficiary and change of ownership forms. Otherwise, any life insurance benefits or cash value could be considered part of the probate estate at death. The grantor should name the owner and the beneficiary to be the trustee of the trust. Because these changes are not effective until they are received and acknowledged by insurance companies, this step should be taken as soon as possible. Another option is simply to name a particular individual as a beneficiary. This means that the proceeds of the policy will not go into the trust upon the insured's death. Retirement benefits require special consideration since both the form of benefit and the choice of beneficiary affect estate plans and can have significant tax consequences. It's always a good idea to consult with the retirement plan administrator about those options available now and in the future. Ordinarily, you should first designate an individual as beneficiary of qualified plan benefits. The trust can be the contingent beneficiary. Again, this is accomplished by naming the trust in a designation of beneficiary form. That's it for part 3 of our series on the revocable trust. In the next video, we'll look at trust administration. We'll see you then.